Yes, Mr. Foster.
If I may just deal with a preliminary question posed by your lordships earlier as to whether it is the intention of the respondent to prosecute the appellant for criminal offences arising from the subject matter of the appeal. In the brief discussion I had with my client, the issue has never been considered or discussed at a policy level, and there has been no focus on prosecuting. I have no more detailed instructions on that, except to say it has never been considered.
Have any of the agents, other than Mr. Lawrence, taken a course similar to him that might have given rise to prosecution?
I am not aware.
I see.
I'm not aware. An issue that I wish to raise directly is the notice to pay a penalty that was offered by the respondent pursuant to Section 21 of the FSC Act. It is not in dispute that at the time the notice offering the appellant an opportunity to pay the penalty was made, the respondent did not have the legal authority to do so, as the insurance provisions of the enabling legislation, the FSC Act, had not yet come into operation. I would submit, however, that the notice to pay the penalty that was offered to the appellant was just that, a mere offer that the appellant could choose to reject or accept. It was intended to be a consensual arrangement between the parties, which, if accepted, would have discharged the appellant from any criminal liability. Having said that, the offer of the penalty by the respondent created no legal consequences. It did not in any way affect the rights of the appellant or impose any obligation on him to do anything. And it would be my submission that the application for judicial review of the offer of the penalty was premature in the extreme, as no decision had been taken by the respondent that in any way impinged or compromised any legal rights of the appellant.
If that's right, the Act Section 21 of the Commission Act, the Commission may give any person who it has reason to believe has committed an offence a notice. Could not the person concerned, if, I'm not saying this is this case, but if the facts fitted it, judicially review that notice on the grounds that no commission, reasonably considering the material before it, could have had reason to believe?
The first response I'd give, my lord, is that the section says where the commission has reason to believe.
Yes.
It doesn't seem to suggest that there must be reasonable grounds for belief. It merely gives the right of the commission to have a reason to believe. The next step is based on that belief, an offer is made. Now that offer is designed to create, if possible, a consensual arrangement where if the other party agrees, there's a meeting of the minds and then there is an agreement.
Well, yes, but it doesn't say...
There's no duty to prove
yeah.
the belief. It is merely intended to elicit an acceptance of it by paying the penalty or a rejection of it.
But the wording is the Commission may give to any person who it has reason to believe. It could have said the Commission may give to any person it believes. Reason to believe does seem to indicate some objective state of facts that leads the Commission to its belief.
I believe that the way it is worded suggests that there should be some basis for the belief.
Yes,
In other words, you must have reason,
yes.
as opposed to having reasonable grounds for the belief.
But the belief couldn't be irrational, could it? It would have to be a rational belief.
It couldn't be irrational.
If
but
it was
not-
irrational, then it would be open to challenge on the grounds of irrationality.
It is not necessarily a belief or a reason that should be the subject of judicial scrutiny or scrutiny by the party to whom the offer is made. What the Commission has the right to do, which it did, was to make the offer, say that they had reason to believe that an offence had been committed, outline the circumstances, and asked the appellant to agree or disagree. Now, if the appellant agreed, there would be no issue about whether there's a reason to believe, because there'd be a meeting of the minds on the issue. If the appellant disagreed, then the next step was for the respondent now to test the basis of his belief by referring the matter to the
I follow that, but I'm not quite sure you've answered the point made by my Lord Clerk. If the Commission irrationally came to the view that the appellant had committed an offence, could the appellant judicially review the notice on the grounds of irrationality? As I understand my Lord Clerk.
You could review irrational decisions on the basis that there was no foundation in fact for that belief or that decision to have been made. In this case, the notice which follows the belief doesn't create a decision or doesn't create an action that affects the rights of the party to whom it's sent. And I would submit on that basis, the court ought not to be inquiring into the reason for the belief, because you reach that stage of irrationality and examination of the grounds when a decision is made by an authority that clearly has no basis in fact, that is irrational, and it has made that decision in a way that adversely affects a citizen. Here, no adverse consequences flowed from the decision to offer the penalty.
But I'm sorry.
No legal consequence.
I'm sorry. It is a legal precondition that there be reason to believe before the notice is sent. Isn't that right? The Commission may give to any person who it has reason to believe has committed an offence.
Yes.
So it is a precondition. It must have reason to believe. Now, if it doesn't have reason to believe, then surely the dispatch of the notice is amenable to judicial review. Even if you confine the adverse consequences to the individual, the receipt of a notice that will be, at best, most unwelcome.
My understanding, though, my lord, is that any judicial review proceedings must issue in relation to actions that affect a party in its rights.
It does
not
potentially affect the party. I take your point that it doesn't immediately have any effect, but if you look at your client's letter, page 14, alternative 2.
And I agree.
They were making a number of threats, really.
It has the potential to affect the party.
Surely he can say, you never had, he could either say you don't have the belief, or you could say you haven't got grounds for the belief. Of course, it would have to be a challenge on the grounds of irrationality. The court couldn't decide what the position actually was, but surely...
The two legal consequences flow. One, if the party agrees, then there is some meeting of the minds, as I said, and there's an agreement. The second legal consequence is the party not responding or refusing to accept the notice, and then a prosecution is initiated. Until those steps take place, nothing in law has occurred that has affected the rights of the parties. In other words, if nothing had been done after the appellant had rejected the proposal to pay the penalty, no report to the DPP,
Well,
there was nothing else.
How
That
far
notice
do you,
itself.
How far do you go with that? What about a notice which is given in bad faith to an individual? Are you saying that individual has, at that moment, no right at all to challenge the notice? That's an extreme case, I agree, but it would be very odd, wouldn't it, if the Commission or one of its employees gave a notice in bad faith, i.e., without any reason to believe, and the recipient can do nothing about it.
It depends. A notice in the context of Section 21, given in bad faith, however unwelcome it is to the recipient, that notice per se does not in any way affect the recipient except that it is unwelcome. It does not give the recipient a right to say, my rights have been affected by this unwelcome notice. I am now seeking judicial review of this notice. I think next step would be some follow-up action by the party giving the notice to do something, stimulating a prosecution by the DPP or some other action pursuant to the notice. Similarly, if no notice had been given and instead the respondent had just reported the matter to the DPP, that report to the DPP would not be the subject of any scrutiny, either by the appellant or a court. So there is no basis in law why the respondent, who when it chooses to offer a penalty, which the appellant is free to accept or reject, should be subjected to scrutiny of whether or not it had reason to believe, when that scrutiny would not have occurred had the matter just been referred directly to the DPP with the evidence for the DPP to decide to prosecute or not.
So do I understand your submission on this point to be that there is no basis in law which to enable a person to whom a notice has been given under section 21(2) to challenge that notice, whether on the grounds of irrationality, malice, or you simply got the wrong person because you incompetently decided it was me, whereas in fact you're really talking about somebody else, and that person has no remedy.
What Section 21 does is give the respondent the right to take two actions based on its prima facie belief. It has the right to report the matter to the DPP, and it has the right to offer a penalty. It's merely a prima facie step, neither of which create any consequences. And I would submit that that step is too early for a party to say that I am entitled to judicial review to quash a decision that, however offensive it may be in terms of the notice, has not impaired or affected that person's rights.
Well, that might be true in the case of a person of robust constitution or reasonable firmness of purpose, but let's suppose it's an extremely vulnerable person who is greatly distressed by the receipt of a notice threatening his or her livelihood and carrying at least the potential threat of prosecution. Are you suggesting that until prosecution eventuates, there's absolutely nothing that that person can do about it?
Well, put it another way, my lord. If nothing happens after the notice has been sent, then no consequences have flowed. There is nothing to affect the person
I
in the
rather doubt
enjoyment of his
that
rights.
someone who would receive a distressing notice like this might so readily agree. I mean, you have to bear in mind the possibility that someone of less firm purpose than Mr. Lawrence appears to have been might be considerably distressed by the receipt of a notice like this.
Being distressed by the receipt of such a notice is one issue, my lord. Having the necessary threshold to reach to a judicial review application is another issue. And you need to separate whether one is offended by the notice or whether there is a basis in law to take judicial review proceedings to quash a notice
What about
that
all
has
those-
had no effect.
Well, there's many cases in judicial review where the applicant actually has no interest at all, no personal interest in the outcome of the matter. I think the Pergau Dam case is one of the ones in the bundles.
Well, there are many cases in judicial review where the applicant itself may not have had any interest in the outcome, but there has nonetheless been a decision that has had an impact in some sphere where the applicant may be an interested party. But in this case, even in a broader sphere, the notice has had no impact in any sphere. It is not something that I would submit is amenable to judicial review.
Well, can I just give you an example? If you look at your, in this case, as concede the force of your point, but if you look at the letter, the alternative to part of the letter, this is what happens if you reject the notice. Now, one of the things that are threatened is commencing proceedings for suspension or revocation of your registration. Now, that's quite a serious matter, and in relation to a whole series of the offences which are in Schedule 4, it wouldn't be a case like this of somebody who had failed to register, but it would be a case of somebody who was on the register. And so there is implicit in the notice, at any rate the way it's construed by the authority on page 14, as a threat to take regulatory action.
Doesn't the next sentence in the letter, the circumstances giving rise to a prosecution and facing regulatory sanctions, doesn't that imply that a failure to adopt alternative 1 will be taken into account in what then happens? So it's not simply a straight choice.
It is in fact a choice. The consequence of not accepting the penalty is a possibility of prosecution. There is no basis for proceedings to be commenced for suspension or revocation of license in the context where we know that the party in this case was unregistered. So that would not be an issue here.
Here, but we're looking at the true construction of the statute. And the statute governs both the cases where the person concerned is unregistered and the cases where the person is registered, but has committed some misdemeanor. Look at Schedule 4. There are a huge number of provisions
Including failure to exhibit a certificate, some very minor matters. But my point is that that last sentence is a threat to take into account the failure to accept alternative 1 and thereby increase the sanction.
The threat to take action if the offer is rejected does not mean that there is a basis to quash the offer that has been made. What one could do is seek to quash whatever steps may be taken because of the non-acceptance of the offer.
In other words,
it gives rise to potential actions.
In this case, in other words, in answer to my lord, what you're saying is that Mr. Lawrence could only have taken action if they had taken it into account in deciding his application for registration, but he couldn't do that prospectively. Is that what you're saying?
I'm saying that Mr. Lawrence could have taken steps at the appropriate time if further action was taken by the respondent.
In other words, if they had taken it into account in relation to his application. But you're suggesting that even if he has an entirely valid basis for challenging the propriety of the issue of this notice, he can do nothing about it until the FSC has taken that into account wrongly.
Well, all the respondent would have done at the time would have been to offer the appellant the payment of a penalty. That's all it would have done. Both parties operated on the basis that the respondent had the authority to do so. Both parties operated on the basis that the appellant was not registered.
But this is a threat. The last sentence is a threat to say to the magistrate, or whoever is hearing the case, not only did Mr. Lawrence not register, but he even refused our reasonable offer to pay a fixed penalty.
But if you look, my lords, under the...
So if you just go to the letter, and just please answer my question. Is that what the last sentence of the first paragraph is saying?
Yes.
Well,
if your lordship looks...
Are you really saying that he has to wait until either that submission is made or he gets a larger penalty for failing to have accepted alternative one?
The offer of the acceptance to accept or reject the penalty is not something that could be used in other proceedings.
Well, they're threatening to use it.
Well, I just refer you to section 21(9) of the FSC Act,
Yes.
which says in any proceedings for an offence to which this section applies, no reference shall be made after the conviction of the accused to the giving of any notice under this section or to the payment or non-payment of a fixed penalty thereunder, unless in the course of proceedings or in some document which is before the court in connection with the proceedings, reference has been made by or on behalf of the accused to the giving of a such notice. So the whole purpose of this provision is to allow the parties to reach an agreement voluntarily that is not used in other proceedings to the disadvantage of the party who may have agreed or who have rejected it.
So you say this sentence isn't therefore a threat to do that very thing?
It's a threat, if it is so interpreted, could not be carried out based on section 9.
Yes, but doesn't that undermine your point that this letter and the notice have no legal effect? Because on its face, the letter is a threat to do something which is prohibited, in fact, by the legislation.
We should not lose sight, though, my lord, that the substance of the letter is the offering of a notice under section 21, which intrinsically had no legal effect to the extent that it did not impact adversely on the rights of the appellant. It could have led to further consequences, but it didn't. And on that basis, I would submit that the application for judicial review was premature.
But you could say, I suppose, that it's not really the letter of the 26th of April, it's the notice itself of the 1st of July, which doesn't contain that threat, as I understand it. That's page 19.
That was the letter of July 1st that sent out the notice, my lord. And that dealt with the offer of the penalty.
Well, that's the notice, isn't it?
That is
under
the notice.
section 21.
That's the notice.
Notice is on page 22. It's in a prescribed form, as required by statute.
Oh, yes, you're right, yes.
That's the form that the party complies with if they agree to pay.
Notice in writing in the prescribed form.
Served together with the letter.
It is served with the letter, my lord.
But all these matters are fact specific. I mean, you aren't for one moment suggesting that your clients are above the law and can spray these notices around the insurance industry when they have no reason to believe it. And they say, well, no judge can interfere with this conduct because
No harm has been done.
somehow on technical grounds, judicial review won't get off the ground. Judges in the Administrative Court in England and Wales would certainly intervene,
It
because our
certainly,
powers are not above the law.
and I'm not suggesting that they are. They do have the power to issue the notices. Not suggesting that they should be entitled to spray it all around,
But you were suggesting that
offending
even
the
if it's
sensibilities
even
of
if
citizens.
it's irrational, no conceivable grounds for it, the courts can't intervene.
We should, though, try to make a distinction between an offensive letter sent by a regulator or authority, which does not affect the rights of the party to whom it has been sent.
Surely there must be a right
steps
not
that
to
could be
receive
taken
these
in
letters.
furtherance of that letter, which then may create an actionable proceeding.
I heard your submission. I was suggesting that one can't have a blanket submission of that kind, otherwise your clients could spray these notices around everywhere.
And I should indicate that in this case, it wasn't a letter just sent arbitrarily. It was sent in the context of evidence that has not been disputed that it was operating, he was operating in breach of the law.
Concerned with your submission that the courts could never do anything about these notices.
A notice that is given under section 21 cannot be valid, can it, unless the Commission has reason to believe. That is the only situation in which there is power in the Commission to issue a notice. So any notice where the Commission doesn't have reason to believe is a nullity.
The law, though, allows that belief to be tested in this way. It is tested if the matter is referred to the DPP for prosecution, and then the Commission advances its evidence. Even if, in a theoretical sense, even if the respondent has no reason to believe, but the person to whom it is sent agrees, that is the end of the matter. The real test is when the Commission acts on that notice by referring it to the DPP for prosecution, and then the evidence that the Commission would have relied on is to be tested in the context of a trial. That is what the law contemplated in this particular statutory scheme.
All right, well, when the day the Commission gave this notice, it didn't in fact, at that stage, have any power to do so, did it?
No, it did not.
How is that corrected in the 2006 Act?
I have two responses to that. The notice itself that was issued by the respondent, even if it did not have the authority to do so, I repeat my earlier submissions that the notice had no legal effect. So there is no remedy open to the appellant to get from the court for a notice that had no effect. So whether it was validated or not wouldn't affect the point that I've made, that the notice had no legal consequence.
Well, it comes to the same point, doesn't it? If you're, if you take the position before the 2006 Act, the notice is a nullity because the Commission has no power to issue it. Is that right?
Yes.
Yeah. The 2006 Act says, if it's in good faith, the purported exercise of the powers conferred upon it in relation to the insurance are hereby declared to have been validly, properly and lawfully done. So, as I understand your submission, it is that at that moment, retrospectively, they were given they were retrospectively given the
Yes,
power
that
they
would be my
previously
second-
didn't have
Yes, ma'am.
to issue the notice.
Yes.
What about the reason to believe that? Is that covered by the retrospective provision?
The retrospective provisions validates every action done by the respondent in good faith.
But is reason to believe something which is in Section 2 of the 2006 Act?
No, it's not. What it says is any action done in good faith by the respondent in exercise of its authority over the insurance industry in the absence of the notice, the insurance provisions notice of the FSC Act. So it seeks to encompass all acts done in good faith. Now, the issuing of the notice
I follow that.
would have been done in good faith.
Yeah.
And
The
that
point
is
I'm making is, I'm not saying it's right, but I'd like to hear you on it. All right, the notice as a notice, and I think to a degree this is my Lord Collins' point, is validated. And in other words, you are empowered to issue notices under Section 21, which you previously weren't. But if you then take this notice, it comes back to the point we were discussing before. Okay, you were empowered to issue a notice, but of course you can only issue a notice if you have reason to believe that the appellant has committed an offence. And on one view of the matter, the appellant hasn't committed an offence because hasn't committed an offence which enables the Commission to do anything, because at the time the Commission didn't have power to do anything. I'm sorry, I put that rather badly.
Let's separate issues. Where the Commission has reason to believe that the appellant has committed an offence, it can issue a notice offering the penalty. In this case, I think there is evidence to indicate certainly that the Commission had reason to believe. As to whether or not it is a matter to be adjudicated upon is another issue, but there was basis in the letters indicating it had reason to believe. Certainly on the facts, one could reasonably contend that when the notice was issued, it genuinely thought it had the power to do so and was acting in good faith in the purported exercise of its authority over the industry. To that extent, when the validating legislation was passed, it, I would submit, would encompass and cover good faith actions done by the respondent, such as issuing a notice.
Well, this is all on the basis that, and perhaps you accept it. And I better put it to you, do you accept that Mr. Lawrence, because the validation law did not extend to criminal offences, was not guilty of an offence under Section 71?
I accept that the respondent would not have had the right to institute or cause to be instituted a prosecution. The Insurance Act.
No, I think that's a different point. That goes to the existence of the Commission. But quite apart from the question of the existence of the Commission for that purpose, do you accept that a person who carries on business as an insurance intermediary who is not registered under that part because there's no way that he can be registered is not guilty of an offence?
I accept that because at that time, the FSC would not have had the authority to register.
And therefore, no offence was committed.
Therefore, no offence was committed.
Now, then the reasonable belief that you say the Commission therefore had that he'd committed an offence is a reasonable belief as to the law.
Yes.
Not as to any factual matter.
It is a reasonable belief as to the law and the facts, because the commission would have proceeded on two bases. You are to be registered under the Insurance Act, and you are not. And two, we have evidence that you have been carrying out insurance business in breach of the Act.
It depends, doesn't it, upon what the ingredients of the offence are. If the ingredients of the offence are simply carrying on business without being registered under the Act, and that's the sole ingredient of the offence, then the position is that the appellant was committing these offences, whether the commission existed or not, whether he could have been registered or not. Because Section 17 simply says that it's an offence to carry on insurance business as an intermediary without being registered.
Well,
The fact that you couldn't be registered is unfortunate, but it doesn't make lawful something which is unlawful if the ingredients of the offence are only that carrying on are two things. One, carrying on the insurance business, and secondly, not being registered. I'm not saying that that is the answer, and it seems to me that there may be a great deal of scope for argument to the contrary, that it could well be said that on the true construction of the statute, Parliament can't, or the draftsman can't possibly have intended a defendant to be guilty of an offence if he couldn't obtain registration because of the hopelessness of the government. I mean, obviously, those are all points which could be debated, but to my mind, it probably does depend upon the ingredients.
it depends on the ingredients of the Act.
Yes, but if the offence is carrying on insurance without being registered, doesn't that mean that every insurance company in Jamaica and all its agents were all committing offences?
If certain ingredient of the offence is not being registered,
Yeah.
yes.
Yeah, but I think you've accepted that the ingredient of one of the essential ingredients of the offence is to be registered with the Commission.
Yes.
Since that wasn't possible, I think you accept there is no offence.
Yes.
Well, I personally don't follow that. I didn't think you did accept that. Speaking for myself, I'm not sure that I would accept that, because if you read Section 70, there are only two things which the prosecution would have to prove. One, that you were carrying on business insurance. Two, that you were not registered. Those are the ingredients of the offence. That's all the prosecution would have to prove. Now, whether the defendant would have a defence, I don't know.
It turns, my lord, I would think, on the ingredients of the offence and how it is to be proved. He could have a defence to say, I could not have been registered because the FSC could not legally register me.
Good.
Or he could say that I wasn't registered. It all turns on how the ingredients of the offence would be considered
Well,
by
it
the
does,
court.
But as my Lord Clark's pointed out, you're not allowed to carry on business, insurance business, unless you were registered. He did carry on insurance business, and he wasn't registered. So, but the corollary of that is, as I understand, so was everybody else in the same position. So everybody's been committing offences.
I would add that he has to be registered under this part of the Act, or every section of which relates to the Commission.
So all the prosecution has to prove is that he wasn't registered under this part.
Well, everyone carrying on business who were registered under the Act with the FSC would have had that registration validated
Oh, but that's different. We're not on
by legislation.
We're not dealing with the case of the person who is registered halfway through and has his registration validated. Because but for the validation, there wouldn't be a registration under this Act. But the effect of the validation would be to validate
The registrations that took
if
place.
there'd been any registration.
The question would be
On the facts
whether
of our case, there hadn't been any registration.
the question would be someone who applied but didn't get registered could be charged with breaching the Act because he wasn't registered, and whether he could now raise a defense that I could not have been registered because the FSC did not have the authority to register me.
But although the registration of other insurance companies and other intermediaries would have been validated as a registration,
There's nothing to validate
there's
here if
nothing,
you're not registered.
There's nothing to to exempt those persons from criminal liability during the period when they were not validly registered.
So the validating legislation would cover registrations that took place, albeit not done by
Only the
FSC,
registrations, but not criminal liability.
not applications for registrations that were pending.
No, I go further. I'd say that that the registration may be retrospectively validated as an act of the Commission, but it's not clear to me that those who carried on business without a valid registration at the time are thereby exempted from criminal liability.
Because if there were, they could raise the defense at a criminal trial. Well, I was not registered and I could not have been registered because the FSC couldn't register me. And that sounds more like a plea in mitigation.
I would like to have clear in my mind whether or not you are saying or conceding that in the case of Mr. Lawrence, he didn't commit a criminal offence.
Mr. Lawrence was not registered, and that is not in dispute. Mr. Lawrence could not say that he didn't breach the Insurance Act because the FSC had no right to register him.
Why couldn't he say that?
Because what he did was to submit an application, was not registered by the FSC. It is very difficult, given the context of the charge under Section 7, for him to say, I have committed no wrong, when the whole process of registration has now been validated by the validating legislation.
It's surely a question of construction of the Act. You could construe Section 70 as only creating the offence in circumstances where it would have been possible to register, but the person hasn't registered. You could construe the section in that way in favour of the defence.
You could construe it in a way to suggest that
if you just give the words their ordinary and natural meaning, then you wouldn't construe it in that way. You'd say the whole purpose of it was to protect policyholders or potential policyholders from people who haven't been properly approved. And the fact that the authority hadn't come into existence owing to an administrative error doesn't affect the underlying basis of the section, which is to protect policyholders and to ensure that it's a criminal offence for every policyholder, for every intermediary to operate without the relevant registration. And that the right course would be for the person who wanted to be registered to make sure that the registration authority got itself registered.
Yes, and that
That would be the argument. I'm not expressing a view one way or the other as to what the right answer is.
Well, clearly it's a criminal provision and must be strictly construed on that account. Is that right?
Yes.
Would it not be anomalous, to say the least, to create an offence of carrying on insurance business without registration, without affording the individuals the opportunity to become registered?
Certainly the literal meaning is to the contrary.
Literal.
But I would like, if I may, just to come back to it, because I did understand in reply to my Lord Collins that at one stage at least you were minded to accept that Mr. Lawrence hadn't in fact committed an offence by not being registered. Is that your position, or are you saying that or is your present submission either that he did commit an offence, or that the question as to whether he committed an offence or not is still open?
Section 70 requires registration. There's no lack of clarity about that. Therefore, anyone who was registered by the FSC, even though it may not have had the authority to do so, would have had the registration validated. If someone was not registered by the FSC, had a pending application, it certainly raises the issue as to whether or not he has committed an offence. And it would be my submission that non-registration with the FSC with a pending application could still constitute
but it's got nothing to do with application for registration. It's the fact
Of
carrying
non-registration.
out the business and the fact of non-registration. It's irrelevant whether or not the putative defendant has made any application or not.
But in fact, nobody could be registered, isn't that right?
Nobody,
That stage.
in a strict sense, nobody could be registered.
Yes.
Therefore,
and anyone
if
who
you carry it to an extreme, everyone who registered with
anyone who
FSC
thought
was
he
unregistered.
anyone who thought he was registered was wrong.
And that is the purpose of the validating legislation, to reach back to retroactively register or have validly registered those persons who were. But that reach back could not cover someone who was not registered. There are other issues with
Well, I think for the time being, if that's all you wish to say on the points we raised, we'll ask Mr. Donkley to say what he wishes to say on those points.
May I just deal briefly with the issue of cost?
Of course.
Under the Court of Appeal rules, parts 64 and 65 of the civil procedure rules apply. Now, part 64 and 65 deals with the award of costs in normal matters. Costs follow the cause. And that is clearly stated in...
Do we have those?
I will provide your lordship with copies of Rule 1.18. So it is clear that the judicial review proceedings in relation to award of costs, that section only applies to first instance. Once you move to an appeal process, you no longer have that facility which is offered.
Well, that, as I understood, is common ground between you. The point made against you is rather more general. It's not in reliance upon that particular rule about no orders to costs and so on. It's a general point that in circumstances of judicial review, it isn't as automatic as a matter of practice for costs to follow the event. And as I understand it, the appellant's case is that the Court of Appeal erred in assuming it to be an automatic consequence of the appellant having lost, if I understand the argument correctly.
That's where I differ. It is not automatic at first instance because the rule gives some facility to an applicant seeking judicial review. That protection is not afforded once you appeal to either the Court of Appeal or the Privy Council. At that point, judicial review is simply saved with other matters.
Yes, I follow that.
May I ask, on what basis did the full court, as opposed to the Court of Appeal, conclude that the appellant had acted unreasonably in taking judicial review proceedings?
The full court merely stated in the judgment that there was no merit to bring the application.
Is that to be regarded as synonymous with acting unreasonably? Or is there any jurisprudence in Jamaica about what constitutes unreasonable behaviour in this context?
May I just find the exact wording of the judgment here? In relation to Justice McIntosh's decision, which is at page 117 of the record, he stated, in my view, there's nothing unconstitutional about anyone of the Financial Services Commission. The application is misconceived in all the circumstances, should be dismissed with cost to the defendant. Justice Marsh did not elaborate except to say that the application would be dismissed with cost to the respondent. So there was no specific explanation given by the court as to the reason why costs were awarded in favor of the applicant. And I would only infer it was because of the nature of the issues raised, how they were argued, and the court's assessments of the actual case.
Yes, thank you.
Can you just tell me where, I've lost it, where is the order of the court below in relation to costs?
That was what we were discussing before lunch. There isn't one. There isn't one.
Yeah, because it
We
says...
we saw the order that was drawn up after the judgment at page 118, which said the issue of costs is reserved for further hearing, even though all three members of the court in their judgments had ordered costs.
My lords, I can only respond that this matter, perhaps I can. There seemed to have been a reopening or an attempt to reopen the issue of costs above and beyond what the printed judgment had said. But they never managed to disturb the order.
Yeah, may I just explain? I believe what transpired is that the court made orders for costs as it did, reflected in the judgment. My learned friend who appeared for the applicant at the time sought audience of the court. The matter was raised by the court, raised before the court, very briefly, but it was not the subject of extensive submissions. The court's order stood.
That doesn't explain why an order was spoken in which the
That
issue of cost was
document-
reserved for further hearing.
That order, to the best of my knowledge, was filed in error. It was filed actually before the attorneys returned to the court to deal with the issue of costs.
Yes.
That would therefore, my lords, leave the position at page 117. And 199.
The common ground is that the court, in effect, ordered,
Costs, yes.
made the order.
Yes, my lord.
Third on page 117.
Correct, my
Even
lord.
though they don't have the order.
Yes. My Lord Saville, I understand you to have invited me to comment very, very briefly on the submissions as it related to my friend's interpretation of the Validation Act, as well as the, if I'm allowed that latitude, to comment very briefly also on his interpretation of the exhibit at page 14 regarding the effect of the notice. In relation to the Validation Act, I have to say that my position was as, not necessarily articulate by Lord Collins, but certainly suggested that he could consider that the validation, between the time that they were without force to the time when validation took effect, no entity in Jamaica was considered registered. And in fact, as a matter of theory, could actually have been moved against for prosecution. No, that would have been sort of like a nonsense or nullity, because it is the same authority that purported to give them registration before until they realized they did not have force of law to do so. But as a matter of law, none were registered, none could be registered, and as at the validation date, it would not have harkened back beyond the date that it was given legal effect. So there was a period of time when all entities in Jamaica, just a matter of interpretation and law, were unregistered. Now, insofar as my friend spent much time stressing that the appellant before this board was never such a person who had a registration, but for the validation would have been registered. He was never registered. He had not addressed the fact that it is in the hands of the respondent to register. And so long as that registration is withheld, he will always be a person who was unregistered.
In the hands of the minister.
No, I'm saying, my Lord Clerk, in relation to getting registered, my Lord, without validation, just on the part of the regulatory authority, it would always be a person who is unregistered because it is not in the hands of another. So when they prepare their notice as though they have reason to believe that you are not registered, when they are the authority who issues the registration, there's a difficulty in that. And he was also not called to book in relation to the time that it took between his filing, because that's why I stressed in my presentation that the respondent did all that he could do. So when my friend speaks to, he didn't register, I think he got the pronunciation wrong, because it's not why he did not register. He has no control over registration. He can only do what he did, which was to file. And therefore, that is why the public authority would have to answer judicial review. Was it unreasonably withheld? And all of the documentation speaks to the fact that it is the umbrella application of the company that has caused the corresponding application of the appellant to not go through. So, just as a matter of fact, it is not that he didn't register. He couldn't do more than he did, which is to file and await registration from the respondent.
Well, he could have stopped. I'm sorry.
Yes.
He could have stopped writing insurance.
So that soon.
Well, my lords, without reopening my arguments, that is the reason why we looked at the 2 years. We looked at the conduct. You looked at the fact that.
Yes, but I'm sorry to interrupt, but if he looked at Section 70 and he said to himself, well, I will be in breach of the law if I don't have a registration. I'm frustrated by the FSC's tardiness in dealing with it, but I don't want to be in breach of the law. Therefore, until I get my registration, I will not write any further insurance. That would have been an option open to him, wouldn't it?
Well, Lord, it actually harkened back to Lord Clark's point about the mandamus. It meant having to do something in relation to this, whether it was by virtue of coming at him with this notice or by their inaction, which would have led to mandamus. Each road takes you back to the control of it.
One's got ultimately to focus on the effect of Section 70.
Yes, well.
Either Section 70 is absolute in its terms. No, I'm not suggesting absolute liability, but that you are in breach of the law if you don't have registration. That's one possible interpretation. Or alternatively, you're not in breach of the law if it's impossible for you to obtain registration. And one, I think, ultimately has to decide which of those interpretations is correct and why.
Well, I believe that as it has played out with us, it is almost without doubt now accepted that during that period of time that it had no legal force, no effect. He was incapable of committing an offence. And the question now, especially when you look at the Validation Act, could it relate back in a way to now create a legal offence against the appellant? Because if it cannot do that, then the state of affairs would continue. And not only that, to my lords, on the subject of reasonable belief, I have to accept the interpretation that at the time when the Validation Act would have taken effect, they would have known during that period that he had not committed an offence, and the subsequent validation could not now give them reasonable belief that he had committed an offence before, because it was not capable of being an offence at that time. So to make it simple, the day before the Validation Act came into effect in 2006, Mr. Lawrence committed no offence. He could not suddenly have committed a criminal offence the day of the validation. Couldn't. He could not have suddenly committed a criminal offence.
The answer to the first point depends upon the point of construction that my lord just referred to.
Yes, sir. Yes, my lord. So it really does turn on that. And for all those reasons, those would be the subject of the judicial review. It goes to the reasonableness. It speaks ultimately to, having brought these proceedings, how should he be treated? It raises the question of how he should be treated as to costs. There are several arguments that would say it was not frivolous, it was not misconceived. And so long as it wasn't frivolous and it was misconceived, we would invite your lordships to consider, A, that perhaps that he had not committed an offence by virtue, albeit of this administrative glitch from the legislature. But that is the reality of it.
But it does come back to my Lord Clark's point, because assuming he knew everything we know now in 2002, the question is, because the Commission has no proper existence in relation to insurance, I don't need to register.
That would have
It is
been a
not
flutter.
unlawful for me to conduct insurance business without being registered.
That
Well,
would have,
he may be right, may be wrong about that.
that would have been a
But I
flout.
think that's the way you have to put it.
I understand, my lord, but this is why in my presentation I stressed so much that he did what he, as much as he could do. At no time did he consider himself to slip between the crack of the gap.
That might give him mitigation,
Mitigation, yes, my lord.
but by itself won't give him a defence.
Unless there was no offence committed, my lord Clerk.
But that'll be a matter for the magistrates, won't it?
It would be actually a matter. Well, it depends on which tribunal is before. At the moment before Her Majesty's Board, the Majesty's Board may also consider that the Validating Act, in fact, even in its present form, may not have that retroactive effect. Even in its present form, does not have that retroactive effect. It would only give effect as at its own date. That is a question and a consideration for Your Majesty's Board. And if he has committed no offence, then the Commission could not consider to proceed against him.
Well, if he committed no offence, it's still open to the Commission, other things being equal, to believe that he had. It might be a mistaken belief.
Not in 2006, though, my
Provided they
lord.
were in good faith, they could still issue a notice, couldn't they?
Well, no, they would have that
Because
difficulty.
the Act says, it doesn't, the Act says the Commission may give to any person who it has reason to believe has committed an offence. It doesn't say the Commission may give to any person who has committed an offence.
But acting on that belief, as they have said, my lord, and it is exhibited at page 14, how they treated with that. They didn't wait for determination from the magistrate, or from the DPP or the magistrate. Once they have acted on that belief, they say they will institute their own regulatory sanctions, my lord, and that will impact on any future consideration of fit and proper. Those are all things that arise once you do not accept the election. And in fact, my friend spoke about a meeting of the minds, and I made a note of that, because if you were speaking about a meeting of the minds, this was exactly what the appellant was complaining about, that had they brought him to a meeting to have that meeting of the minds, as opposed to sending it to him in the form of a notice, a most unwelcome, as Lord Card most succinctly put it, notice. They may have had that meeting of the minds that would have avoided this process, because without that, it has the appellant becoming a very sophisticated interpreter of statute in order to determine whether or not this would be an effective notice, or whether he should wait for the prosecution to deal with the stigma of the prosecution, because once you're arrested and charged, that in itself is an onerous experience, separate and apart from being acquitted. And for the time that it takes in our jurisdiction, some 3 odd years, he would have been a person under charge and out on bail, facing $3 million in fine, or 3 years to hopefully be exonerated from his perspective, or take judicial review if he's challenging how they arrived at that in the first place. So when my learned friend made submissions to your Lordship's board in regards to waiting and the premature aspect of it, would he have waited around for that? And also, they used the words will, my lord. So all of my learned friends spoke about the fact that they would have to act, and if they hadn't acted as yet, then he is premature. The notice of page 14 indicated that the Commission will refer the matter to the office. This is at page 14. Will refer, your case will be referred to the Office of the Director of Public Prosecutions for prosecution. Additionally, the Commission will commence proceedings. So, insofar as it is not good public policy to have a regulatory authority speaking in these terms, well, you'd have to take them at their word that they are going to act on that, and in those circumstances has sought judicial review. Page 14, my lord. Alternative 2. If you reject the fixed penalty option, your case will be referred to the Office of the Director. So unless I can be of any further assistance to your lordship, sir.
Was there anything else you wanted to say to us? Do you have any further submissions?
My lord, I only thank you for the opportunity to restate.
We will rise for a moment to consider the matter, but we will return shortly.
Oblige me, lord. This way and that.